Hi everyone, and welcome back to my channel. If this is your first time here, my name is Jennifer Etherton. I am the founder of Moonlight Mobile Notary here in Fishers, Indiana. Over the past few videos, we have discussed living wills and last will and testaments. If you missed those, I will leave a link to them in the description below so you can review those after you've finished this video. This week we are going to step back a little bit and talk about estate planning as a whole and what documents are usually involved. Estate planning is more than drawing up a last will and testament, maybe having a living will and calling it a day. This isn't a set it and forget it type of deal. This video will only include a brief overview of what estate planning is and the importance of the different documents that are involved. The rest of the series will be a deeper dive into the individual documents so you can become familiar with them and choose which elements are best for you. One of the major misconceptions is that estate planning is only for the old and the wealthy. This couldn't be further from the truth. Everyone benefits when assets and finances are properly protected. Not only that, a proper estate plan will prevent the probate court from distributing your property to the wrong individuals. Another major misconception is that estate planning is only for the distribution of your assets after your death. The reality is, half of a successful estate plan has instructions for a designated individual to follow if you become incapacitated. It's one thing to know you need a successful estate plan to protect both you and your loved ones. But the question is, where do you start? There is a wealth of information and it can become overwhelming to know and understand the different documents and legal terminology needed to create an estate plan that is right for you. It is vital that you sit down and outline your wishes and instructions for not only your loved ones, but the courts to follow after you have either become incapacitated or have passed away. You must remember, verbal instructions mean nothing in a court of law. So get everything in writing and properly witnessed and notarized to make sure what you want happens. So let's go through this process step by step. And step one has nothing to do with your estate plan documents. The first thing you need to do is evaluate the people around you. This includes both your friends and family and any professionals that you have around you as well. You need to ask yourself, who do you implicitly trust? Who is both dependable and responsible? And who do you think will be able to carry out your wishes to the best of their ability without letting their own values and wishes cloud their judgment? You need to identify an individual or a group of individuals who are both trustworthy and dependable. It is vital that they each have both of these characteristics so you know your wishes and instructions will be followed to the letter. It is not only vital that the individual or group of individuals have these two characteristics, but it is also important that you understand that this process is involved. This person or persons will need to have the time and the will to put in the work necessary to carry out your instructions or to liquidate your assets after your passing. This individual or individuals could be called upon to wear many hats, including being the designated individual for a power of attorney, to be the executor of your will, a trustee for your living trust, or any number of other quote-unquote jobs that are required by someone who is tasked with carrying out your wishes. This also includes distributing the information in your letter of intent. While this step will be more difficult for some than others, it is vital. There is no hope to have a successful estate plan without first completing this particular inventory. Step number 2 is drawing up your letter of intent or letter of instruction. Once you have chosen your designated individual or group of individuals, it's important to give them a roadmap. Your letter of intent is an informal letter. You do not need an attorney or any witnesses for it. It is a letter that is given to your designated individual upon your passing, or at the very least is put in a place where they know how to find it. This letter can contain any information that you choose. However, it is vital that certain points are addressed. This includes where you keep important documents, such as your trust, your will, your statement of net worth, any bank statements, life insurance, and a list of your remaining debts. Also, important account numbers, passwords, and your usernames, so this can be given to your executor to help settle your estate. Also, the personal contact information of friends, families, and others that you want to be contacted upon your passing. This also could include your financial advisor and attorney and any other professionals that your executor will need to speak with. Don't forget to include any benefits you have, whether it's Social Security, military benefits, certain pensions, even things such as IRAs and investment. If you have a safety deposit box, you need to outline where it is, what bank it's with, where the keys are, and instructions to the bank to let your executor into your safety deposit box. Each bank is slightly different, so I would recommend speaking to a bank manager or a personal banker to get an outline of what you will need to allow your executor to get into your safety deposit box when the time comes. You can also have a list of little things that you would like to be given to certain individuals. Say you have a favorite ring or a favorite necklace, maybe a pocket knife, or something small that you would like to given to a certain grandchild or great-grandchild. Not something that's really big enough to put in a will or a trust, although it can be put in there, but something that would seem insignificant to someone outside the family or someone who doesn't understand the sentimental significance of an item. So step 3. You have now got your designated individuals or group of individuals. Your letter of intent has been drawn up and is looking good. You have either already given it to your designated individual or put it in a place where they can find it easily. Now it is time to draw up your will or to have a living trust set up. Now, a last will and testament is pretty standard. I've actually already covered it, and I will leave a link to that video in the description box below so you can review it. But just for a refresher, a will is a legal document that is drawn up that outlines your wishes on the distribution of your assets. When drafted according to your state laws, it will ensure that your instructions are followed. Now, it is important to remember that last wills and testaments are required to go through the probate courts. Now, a last will and testament or a living trust is the cornerstone of your estate plan. So it is important that you take the time to make your outline as detailed as humanly possible. This will ensure that no mistakes are made. Whether you have a large estate or a small one, if you have any assets whatsoever, it is important that you have a last will and testament or a living trust. Now, anything can be an asset, but these largely include real estate, cars and other types of vehicles, business profits and assets, bank accounts, investments, insurance policies, retirement, pensions, any type of military benefits, Social Security benefits, and the list goes on and on. You may be surprised just how big your estate actually is. Now, we have discussed last will and testaments. They're easy. A lot of them can be DIY'd, and it's what most people think of when it comes to an estate plan. On the flip side, there are trusts. Now, trusts are different from last will and testament. The first is it can help save on estate taxes. Another thing it helps prevent are legal challenges. The way it helps reduce legal challenges is because you set up a living trust well in advance of your passing. It is usually set up decades in advance, so it is much harder to claim that an individual was under undue influence or incapacitated at the time the trust was set up. It also has other safeguards in place to help prevent these types of legal challenges being put forth. A living trust is a little bit more involved. It's not just enough to set up a trust. You also have to fund it. You have to put your property under the guidance of the trust, and it's usually overseen by a trustee. Now, this trustee can be you, but it is usually either a friend, family member, or a professional trustee who usually works for a financial institution, but also can work at your attorney's office as well. Now, it doesn't matter if you have a last will and testament or a living trust. The important thing is that all of your assets are included. The assets that have been left out of your last will and testament or your living trust will go through the probate process and may be designated to individuals you do not want to inherit. So it is important to keep on top of any changes that are made during your lifetime. We have touched on the basics of what a living trust and a last will and testament are, and how they are the cornerstone of a successful estate plan. It is not enough just to have a last will and testament or a living trust. The wording is critically important. These are legal documents, so any word out of place can drastically change the meaning behind your wishes or instructions. There are some instruments that are outside the purview of a last will and testament or a trust. Most of these, or all of these, have designated beneficiaries themselves. You can include them in your will, but it's important that the beneficiaries stay consistent. You don't want to have your 401k being bequeathed to two different people. It gets very confusing. There is a lot of legal wrangling. It will have to go through probate. It's always best to make sure everything matches the way you want it to. When it comes to these instruments that have named beneficiaries, it is also important that you keep them current. You don't want a 401k going to your ex-spouse if you're not on good terms with them. So always make sure that any major life events such as marriage, death, divorce, major moves, you take the time to update your beneficiaries so someone you might not like or have not been in touch with for many years doesn't get a windfall you wanted to go to someone else. Not only that, if you have children or you're planning to have children, this is the time to designate guardian who will take care of your children if you pass away too early. Designating guardians for minor children are widely overlooked because most of us think we will outlive our children's formative years. We all hope to see our children grow into adults. It is always best to plan for the worst case scenario and just have someone in place in case the worst happens way too early. And just like with beneficiaries, it's always best to choose two sets of individuals, the primary and the contingent, because you never know what life is going to throw you. So step 4. Step 4 has to do with if you become incapacitated. We would all like to think that when we pass away, it will be 1 minute you're here, 1 minute you're not. Unfortunately, this doesn't always happen, and it's important to plan for the eventuality where you may not be able to take care of your own finances. This is where living wills, advance directives, and powers of attorney come into play. I will be making a couple of videos outlining powers of attorney and their importance. I have already posted a video on living wills and advance directives. I will only give you a brief overview here, as I go into much greater detail in those videos. A living will outlines your end of life or palliative care wishes. So this could be anything from a do not resuscitate order to whether or not you want a feeding tube, whether or not you want to be on life support. The most important thing is that living wills and advance directives gives your medical team a path on which they can take. They are your specific instructions. No one is guessing. No one is letting their own values cloud their judgment. Your medical team knows exactly the procedures that you want to endure and which ones you would prefer not to. There are a whole host of questions. I won't go over all of them here, but it's important to take your time and really think about what your end-of-life care should look like in your eyes. This is based on what you want, your value system, and what you want to endure at the end. Now, your living will and advance directives will allow you to designate someone to make medical decisions on your behalf. Powers of attorney also do this. Powers of attorney are interesting because they deal with both sides of humanity, both the medical and the financial. You can have one person designated to talk to your doctors and help make medical decisions, and have another person dealing with your bills, making sure that your finances stay in order and in your bills in good standing. Speaking about bills, this is also a good time to make sure that you have enough life insurance. Life insurance has been thrown around. It can be considered a joke, but it is vitally important. It will help your significant other pay the bills, especially if you are the breadwinner. The simple rule of thumb is 10x your yearly salary. So if you are making $100,000 a year, you need $1 million worth of life insurance. You can adjust this up or down based on your yearly salary, but this will allow your significant other to maintain his or her lifestyle while they are getting through a very difficult process. Step number 5 is maintenance and upkeep. You want to make sure the people inheriting the wealth that you worked hard to build are the people you actually want inheriting. Anytime there's a major life event, such as birth, death, marriage, divorce, a major move, even a job change, make sure that your beneficiaries are up to date and people that you are still in contact with. You don't need some ex-girlfriend or boyfriend getting a windfall and they haven't seen you in 20 years. So always make sure that your beneficiaries, designated individuals, are up to date. Not only that, it's important that these individuals are part of your inner circle because they are able to watch your value systems morph and change over the years. Now, I know this video is a little long and there's a lot of information packed into such a small space. Don't worry, just rewatch the parts that you've missed. I hope you took notes, and you can always revisit this. I'm not going anywhere. It's also important to remember that we live in uncertain times. It's always best to get an estate plan in place so at least you know your family and loved ones are taken care of in the event that the worst happens. Not only that, you know that you are taken care of if you can no longer take care of yourself. If you found this video informative and would like to know more about estate planning, the notary world, real estate, or just adulting in general, don't forget to hit that subscribe button and the notification bell. And if you enjoyed this video, please hit the thumbs up button. Next time, we will be continuing the estate planning series and discussing the importance of living trusts. So I hope you have a wonderful week, and I will see you on Wednesday. Bye!